Good afternoon, everyone, and welcome to our Foundational Friday webinar hosted by the Florida Urban Forestry Council. My name is John Snow. I serve as president for the Florida Urban Forestry Council. I'm a board-certified master arborist and certified urban and community forester. I'm glad to see so many professionals joining us for what I believe is a very timely and important conversation. Today, we're focusing on tree risk assessment in Florida, specifically how to properly interpret and meet the requirements outlined in Florida Statute 163.045. There's been a lot of discussion across the state about what constitutes a compliant tree risk assessment, what the statute actually says, what it does not say, and how reports should be written, plus how municipal staff should review them. Our goal today is to help provide some clarity. We'll look at key terms, discuss what compliant fieldwork and reporting should include, touch on municipal code concurrency, and walk through examples that highlight strong professional practice and some that may fall short. We'll also leave time at the end for Q&A, so feel free to drop questions in the chat as we go along. It's my pleasure to introduce my colleague and co-presenter, John Harris. John is a landscape economist, urban forester, and consulting arborist with more than 40 years of experience in the green industry across North America and the Caribbean. He's the principal of landscape economics, where he provides expert services involving tree and landscape damage claims, valuation, and litigation support. His professional credentials include ASCA, Registered Consulting Arborist, ISA Certified Arborist, ISA Tree Risk Assessment Qualified, SAF Certified Forester, and Tree and Plant Appraisal Qualified, among others. He also holds 4 college degrees, including a Master of Science in Forest Economics and an MBA. John brings a unique combination of field practice, economic analysis, and defensible reporting experience to this topic. John, thank you for being here. I'll turn it over to you to get us started.
Hello, and thanks, John, for bringing me in for the February 2026 webinar, our Trees and the Law series. I'm glad to be coming back with some 2026 information, or maybe what I should say is bringing us up to date, especially about tree risk assessments and the municipal ordinances in relation to our, ongoing Florida Statute 163.045 and how we're doing working with this. One thing that I did want to say is I thank John for his help in reviewing the slides and the information and using his AI assistant to help me get some, I'll just say, better slides with what's going on. So let me go ahead and get started with thanking everybody for attending, and I'm hoping and obviously seeing that we do have a good mix today of private companies, people working as arborists, likely writing these tree risk reports in relation to whether or not a tree is considered a high enough risk with enough damages that it could qualify to be removed under the FS 163.045 terms, as well as agency employees, whether county or city or even state agencies, and how we're all dealing with and reviewing these situations with, hopefully all of these are dead and dying, or, trees deserving of removal for all the right risk reasons, as opposed to what some of us are finding, which is trees getting reports written that really don't deserve to be removed. And that's really why we continue to talk about this and talk about how we can continue to enforce our codes, as well as improve the writing of these reports. So starting out with, I think everybody here knows who I am. If you don't, some information for you. As of this year, I do have 47 years of being in the industry. The one important point that I do want to point out, as those of you who want to read can read my background, is The Q&A in this webinar, different than a lot of my presentations, we are following the format. So we're going to have questions and answers at the end of the presentation, not throughout. So please do, as everybody has done well in most of the FUFC webinars, use the chat and put your Q&A questions in, and we'll be answering them at the end. So one of the things to start off with is that, you know, even at this point, 2026, we don't have any other revisions, excuse me, that have happened with the Florida statute. So we are still learning to work with the terminology that's been there all along. So one of the points to make with this is that the tree risk assessment or track program actually has had some updates, but in this ordinance, we're still working within what's defined here under section 2, which is tree risk assessment or best management practices of tree risk assessment, the 2017 second edition. So that's one important point to make, especially when we are working within ordinance codes or regulations, is some things are dated, and we need to remember that we're following those dated documents. One of the things that we do in our company is try and take information that we get from other sources and maybe format it, set it up, helps us to view it and see it a little easier. So I'm just giving you an example of doing that with the ordinance, or I'm sure say with the statute, excuse me. So putting everything together, I like to give most of the high points in a single slide so it's easy for people to have the checklist. So some of the key points or key terms that we really need to know in the 163.045. That there is a requirement for documentation, documentation following the tree risk assessment standards. So the ISA certified arborist is one professional designation. The other professional designation is a Florida license, or normally what's now called registered, but landscape architect license to practice in the state of Florida. So only those two professions are given the right to write these tree risk assessment reports and provide their opinions towards what does or does not make a tree a candidate for a property owner to decide to remove it following this permit exemption. Property type is also pretty tightly defined. Again, residential property, single family residence. So there are some local code definitions of single family residence that includes duplexes. I think there's a few places where even a triplex may come under a single family residence, but so it's a single family as it's defined for the land use in your locality. That may be something that everybody wants to look at and check as well. Thirdly, the risk level. So it's an unacceptable risk to persons or property. Imminent hazards normally come with unacceptable risks, and also that it's a high risk. And it is the professional who did the tree inspection, did the tree assessment, as well as wrote the report that is providing that opinion. It's not the opinion of the property owner that they gave to the profession. And as much as that sounds like it should be pretty straightforward, sometimes those are the arguments that are made by property owners. The on-site assessment that's required has to be performed within the best management practices for tree risk assessments. So again, like I said before, using those languages and those BMPs, not looking at some of the changes that have been made more recently. So we're not talking about remote views or not making an assessment. We're talking about being on site and actually inspecting the tree as the certified arborist or the licensed landscape architect. So that we move from the assessment to making the determination, or really the one opinion that needs to be provided and given evidence, which is removal the only means of practically mitigating the risk, or its risk being the tree's risk, below moderate being moderate being the risk assessment level that basically is considered, at least in this statute, to be the difference between being an acceptable risk for a single family property owner versus an unacceptable risk. So this removal as a recommendation or as a one activity that would mitigate the risk below moderate is the decision and is written by that certified arborist or landscape architect. So again, like we talked about, the property owner is the one that decides whether or not they should, again, follow through and get a permit, or whether everything is done following the regulations, so they decide to do the removal without getting a permit for that particular tree. So obviously coming out of that, we have some situations, I'll say like in development permitting, where there are reports being written based on future potential conditions. So one example would be, a tree that's lifting a sidewalk. So is the tree in the current condition actually a risk that would meet 163.045's permit exemptions, or would it be the cutting of the roots, I'll just say within inches of the edge of the root crown or inches of the trunk base, that actually would cause that to be a higher risk, whereby removal of the tree after those roots were cut could be what would fit with this as far as the permit exemption. And that's really, again, a situation where, to me, enforcement can be brought, because the tree, as it's standing on the site prior to any additional work, so currently on the site, is the tree that is supposed to be being assessed in those conditions. So just one example of how that works. So one of the things for me, and one big conclusion that I've made in other presentations, is really this law should not be getting trees removed that would not otherwise meet with, in some cities, the hazard tree or risk tree definitions that are in those local regulations and local ordinances. A dead tree that could meet all the requirements of the FS 163.045 is the same dead tree that would have met the local ordinance allowing for it to be removed without a permit in some cities. So just, as a consideration kind of globally, to me, there shouldn't be trees that are being removed under this FS 163.045 permit exemption if they weren't already actually going to qualify in some cities for the permit exemption category as a hazard tree. So just think about that, keep it in mind. So one of the reasons that obviously we're here and presenting about this over again is to remind all of both those who practice as private arborists, as well as those who work for cities and counties, is that there is the challenge that can be made when these reports are being done not according to ISA ethics, not including evidence to support the opinions of the arborist, and the tree, in reality, in the pictures or maybe in a site visit, doesn't show the conditions that would make it, excuse me, a high risk or have any imminent hazards. So we've already had the legal challenges to defend that cities, counties, or municipalities, local jurisdictions do have the right to question and challenge these reports, and can have the exemption, in a sense, overturned, or that in a co-compliance case, it can be proven that the tree wasn't exempt from getting a permit and should have been required for a permit and all of the permit requirements therein. So again, some of the key points in this is, who was that person doing the on-site assessment? Are they currently an ISA certified arborist? Are they currently a Florida licensed landscape architect? We all can look each other up in a sense and see if we actively, hold these credentials. The information and the documentation, does it show definitively that it was a residential single family property? And I'll say both in photographs, or maybe actually quoting the tax information from the property appraiser's office to provide that evidence. How was the on-site assessment done? Did it follow the ISA tree risk assessment BMPs? How do we determine that? Is how that's actually written up. And is that arborist or landscape architect using terminology from the tree risk assessment in their report to provide how their assessment was done, the level of inspection? To me, a level 2 is probably the minimum requirement to be able to provide a report like this, because you do need to at least be inspecting the tree on site. You need to inspect all sides of the tree from the top of the tree to visibly, roots in the surface of the ground, to be able to provide opinions about the total condition of the tree. So then in the end, the decision and the language again, as it's written in that report, isn't an unacceptable risk to persons or property. So it is, to me, easy to look at these trees, or hopefully be able to see in reports that are written ethically and with the information, to be able to make a determination of those trees that should be challenged and those trees that really did meet the need to be removed because of that high risk. So, just to use some graphics, right? So residential only and the right to challenge is just, again, what I'm confirming here. So what is the standard? The standard being the unacceptable risk to persons or property, and the fact that, is there other mitigating or mitigation activities that can be done, from pruning of different tree parts to reduce that risk, within obviously the limitations of working through that tree and not removing more canopy than the tree can support being removed. Maybe cabling or bracing could be done as a practical mitigation for the risk in the tree, but not always is that going to be able to be done or be done successfully. But we do have to show that consideration for what are the other tree maintenance activities that could reduce the risk, why those don't fit that particular tree, or and/or that particular site, and why removal is the one or only practical means to mitigate or bring the risk for that tree below moderate. So really, we all get to this point and we all look at how does it end up being the battle of experts? This is what we all talk about, in the halls, is one case or another, or one report or another. And it does come down to, looking at and reviewing and making sure that reports are written ethically, that the qualifications of those, both those who are working for a municipality as well as those that are the practicing arborist or consulting arborist, that is the qualified certified arborist in the work that they're doing. But, we're really emphasizing that, reviewing these more, should be done. And, as we've worked with this law for, plus or minus 6+ years, we are, gotten through a lot of situations and a lot of tree removals, as well as a lot of reviews. So we should all be getting to the ability to work with this law and understand it at this point. And that's my hope in summarizing this again. So the other point, which I think is worthwhile, because I don't know that every city, every county has actually done this, but every city, county does have, whether full-time or contracted to the agency, does have legal advice or an attorney. In some cities, this example is actually from Coral Gables, did obtain and have on record what the review was by that here city attorney, and what the interpretation is for the following this FS 163.045, again, in this situation being Coral Gables itself. But other cities also have obtained these opinions and have that in support of the ordinances that have been written to include the exemption and support of the exemption. So again, if you haven't done this in your local jurisdiction, it's something that I recommend you should do, so that you get the support of and the understanding of your legal advice, which probably goes through the manager level as well. And I don't think that well, I won't say every, but that most cities have gone through this formally to be able to get this level of support and documentation for when they really have some, I'll just say, large violation cases of trees being removed when they weren't hazard trees or didn't achieve the level of high risk that should have qualified for this permit exemption. So moving on from how to apply the regulation and what's in the regulation, it really does come down to the reports, and I'll say the quality of the report, or at least the report provides the minimum information that's required to have in it to show following the risk assessment standards, as well as the information presented so that it's understandable. You're writing for a professional audience, so this isn't about a letter. And I have read some reports, as I'm sure other people have as well, that it's basically written as if somebody was writing to their friend down the street or a family member about the tree that I saw and the condition of the tree and what I felt about the tree and how the homeowner feels about the tree. And it's not about feelings. We're supposed to be talking about facts, and one of the best ways to show that is in how objectively you write your report. The other thing is not writing more than you need to write. It is, again, supposed to be a pretty well formatted report, so it's easy for anybody that requests it and reviews it to be able to see the information that should be in there. So as I've done in other slides, here's a components of what I call a useful report or a defensible report. What is the report for? Obviously, who did you write it for? The date of the report, that would include the date of the inspection. The what and why for the report, how your assessment was done, following a level 2 or maybe even a level 3 or level 4 assessment, what was included in that assessment, what in a summary are your opinions, methodology of what you followed, and the tree data that you have. I recommend always to have photos, and I think really to prove the condition of the tree, it really is about including photos and using the photos. So, in my company and myself, we don't ever write these tree risk assessment reports or just other arborist reports without including photographs of the trees. So let me share with you a couple of examples, pretty maybe good on the best side and bad on the worst side, but it really does make the point. So, reports that are just written to show that a tree's being removed for safety reasons doesn't provide any of the language, right, in the tree risk assessment, or, quite frankly, any of the information, that is in the statute. That is really the language that, for those of us doing these reports regularly or reviewing them regularly, excuse me, is what we're supposed to see. So aside from vague terminology, the methodology, like I said, is missing in this report, and the tree information doesn't really show what makes it a poor condition. Where do you get a poor condition for any of these trees that are listed? And, quite frankly, it doesn't say the reasons for one or the other to be removed and how they qualify it to be a permit exempt removal versus a removal that should still go through the permitting process. And then lastly, where is the rest of the evidence? I don't see it either. So one of the other parts of bad examples and bad reports, to me, they can cause, or in a sense they should cause, enforcement actions to be taken. I have been involved in reviewing as an expert, both an expert for tree service that was found removing trees under the exemption, whether or not they should have obtained a permit. So in the code compliance case, or also as a an expert to one city or another in reviewing their code case and information on it. And yeah, even, like in this one, I'm not gonna, show you all the information, but this is a Miami-Dade County where actually the police were called out. Neighbors complained, and they actually stopped work on the property, shut down the tree service, and actually wrote in here their last point was that even the police in this particular situation advised the need to have a permit to remove the tree that had was in the process of being removed when the police arrived on the scene. So enforcement can be, basically that dramatic or done with, all of the formality that it can happen. So if we go to the other side, to me, it's not hard to write a compliant report. The trickiest part is to remember that writing the report with the same format, with the basically most of the same information is the best way to write these reports so that again, it's easy for anybody reading them to find the assessment method that was followed, find the evidence and the information about the trees, and find the opinion using, again, the information and words from the statute that really make sure that in that arborist report or landscape architect writing what is supposed to be the tree risk or arborist report um, has met the terminology and met the threshold for what level of risk does that particular tree or maybe more than one tree have to be exempt from a local permit. A couple of just some more examples. Some may be like on the left actually was for multiple trees, or they may be for single trees. And you'll see on the right side, right in the title, residential property defined, and then the pictures that go with this report would show the site overall and the aerial of the site so that there's no question about what the land use was and whether it was a single family residence. So in the end, just pulling it all together, the regulators review checklist, or this also could be the arborist or landscape architects review checklist. The main point of the theme is that you're inspecting the tree as it stands. So the conditions that that tree has on the day that it's being inspected, but then the key points for review and whether you should or shouldn't be doing these reports as a contractor, and on the other side in reviewing and deciding whether or not the report was done following all of the regulations is the qualifications actually were met by the author of the report. Is the tree actually in a single family lot? Did the site assessment or tree assessment actually follow the best management practices for tree risk assessments? And does the report use the language from the statute? That removal again is the only practical action to reduce the risk below moderate. So it does take getting a copy of the report, even after the fact when the tree's already been removed, but neighbors have complained about it, or people have sent in pictures of that they had of the tree before it got removed. But there needs to be a report to be able to support that removal. So again, I'm just saying this kind of my conclusion is that this law should not be removing trees that otherwise would not have been designated even within a city's current municipal ordinances as a high risk or a hazard tree that would have been approved for removal every day. And my hope is as we progress with this law being in place in Florida, it continues to be used closer and closer to meet that conclusion, or to me, what should be the only trees or palms that fit with meeting this regulation. So with that, I'm ending my presentation to kind of bring us together with this again. Hopefully have brought up enough points that have generated the discussion right in the chat. And I know we've got a list of, excuse me, questions to answer. So at this point, I will close out on my presentation and I'll get back with John and we will be ready to be answering your questions. And I appreciate everybody listening to me and hopefully the information I've shared with you is going to help you do a better job tomorrow than you did yesterday because we're here together today to work through this information and learn more. Thank you.
Wonderful. Thank you, John.
Okay,
Can you hear me there?
I hear
Aw-
you, and everybody should be able to hear you as well.
Awesome. So yes, we definitely have a few questions in Q&A. I think I know you had kind of queued up the chat. Check that as well. Hey, Joe, good to see you.
Yeah.
And so we'll start rolling through. But before we get started with some of those questions, I got a couple questions of my own that are kind of interesting. So right now we're about 6 years into this statute. And in your opinion, are we seeing professional standards improve statewide, or are we seeing more creative interpretations of the exemption language?
Well, I would say, you know, like for the sake of it, when ANSI A300 and pruning standards come out, or when codes were written that hat racking was tree abuse and tree pruning doesn't look like a tree with stub cuts, we are even more decades past all we know about that, all we enforce about that, all we educate and train about that. But there are plenty of people working for money that don't care, are uneducated, and or just don't want to have to work that hard or think that hard, and yet are still touching our trees. And that just upsets me. But this regulation, was written to, and again, principally to allow for trees to be removed, single family homes without mitigation, to provide some um, relief for those residents who really have trees that have reasons or purposes to be removed. Not necessarily am I going to the one example of trees that need to be removed because somebody wanted to add a garage to their house. This isn't an alternative to development permitting, which goes back towards a couple of these questions. And that to me, it continues to be one of the worst infractions or worse abuses or misuses of FS 163.045, which rolls off my tongue way too easily because we're talking about it at least every week with somebody. But no, this isn't about removing the trees before you get your demo permit, just because you still have a tenant in the house. You really
Oh,
should be turning in your plan and your demo permit and permitting the removals, but for those homeowners who are living in the house, it definitely is a way for them to get that, what in some cities, like I state, removing a hazard tree. To me, that should be synonymous with when people are willing to do an arborist report and with being able to have a compliant arborist report. So I'll just stop there. Yeah.
there you go. That's awesome. Thanks, John. So Dr. Ali has a question,
Yeah.
and he's hitting right on where I was kind of going as well. The new tree risk assessment BMP version, that's the 2025. It's now in its third edition. Um, will the statute reflect that? We were talking a little bit about this backstage.
Yeah. So, the references that are in regulations, it used to be, you know, I'll just say for this regulation, you used to be able to write based on the second edition 2017 and any more recent editions and any revisions such to. And through, I'll just say, legal challenges and legal advice, it has now become standard to take that allowance for incorporating or encompassing that a lot of, especially industry standards, not just our industry, but engineering and architecture and carpentry and roofing, blah, 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 change on a regular basis, especially with technology materials. So the only way that the statute would change for the reference is the statute would have to go through the whole revision process to be updated to this. And there are, pros and cons to that. One, getting to new language and maybe getting to change some of the terms that really don't have a definition in the standards that are in this. But the other alternative is that opening this up for revision completely opens it up for revision. So there are others who are
Right.
like, we've learned to live through this. Let's just continue to live with it. But those are the two ways that goes. So right now, unless you've got, a good lobbyist that has the ear of every legislator in Florida, I would say don't expect this to get revised, even in the next 5 years. So.
Yeah, I would agree, and it's, kind of segue off of that. So, yeah, newer arborists, let's just say, that are now going through the BMP training, the track training, utilizing the 2025 version are kind of at a disadvantage because they don't necessarily have that old standard. Do you think that could be a problem going as we move forward, say another 5 years with this statute?
I think that um, is going to come into people's practices, in a sense, having let me get my hands right in the picture, but anyways, the 2017 compliant FS163.045 tree risk assessment arborist report form that a lot of us have because we're doing these regularly, and our new compliant
Yeah.
2025 third edition that has that information and just to say I'm going to my track renewal sometime this fall, so all the new edition is going to be drilled into my head as well as tested out of my head. So I'll have more news about what I think about that, probably in 2027.
Yeah. Yep. That's really interesting because, I think as we're writing reports, what I'm hearing here is we need to be explicit that we use the 2017 standard, not the current standard as we're writing a report, because that would be an automatic, technically a rejection.
Yeah, can be, would be, should be, right?
Yep.
But only for those reports that get reviewed, which is, another part of how this regulation works is the homeowner can get a report, can remove the tree, and when nobody with the authority to provide a code violation heard the tree fall, nobody heard the tree fall.
Yep.
Whether it was, a live healthy tree or a tree that, had the right reasons to be removed under the statute. So let's try another question.
Sure.
Laura's question:
Yeah.
evaluating trees for future use or just as it stands now. So, this is what happens in development permitting for sure, as well as just, other types of property damages. So we run into this as a scenario for sidewalk or roadway repairs with swale trees as a great example of tree for future use. So we'll go and do a tree inspection for a sidewalk repair, whether it's next to a single family home or a commercial site. But the point is, the tree doesn't become a high enough risk many times until the roots have been cut for that repair. So the report is being written in those scenarios, permit wise, as for what would be the risk level for this tree after the roots have been cut. Therefore, if you're going to repair the sidewalk, then the tree is a high risk and needs to be permitted for removal. Not the same as the tree as it stands there today, following this regulation. And let me click this. This is not legal advice. This is an experienced arborist who works with this regulation and teaches it regularly. My opinion is it
Well,
is and it's meant to be as it stands today, and that's how most of the reports that get reviewed formally in court cases, that this is a part of those reviews for me basically every time.
I agree, John. I've reviewed reports as well, where, oh, the tree, is lifting the driveway and therefore is a high risk tree. And it's, well, no, the tree itself is not a high risk tree until you cut those roots. And so, there's this kind of, I think some people get a little confused with the issues. And then, as it relates to like site development, first of all, is it single family or not? And in most cases it's not,
And let
or
me
you don't
let
know.
Yeah, let me touch on that and get into this answer to the
Yeah,
anonymous attendee question about specifies actively used for single family residential purposes. So
that's where I was going.
as it states, single family residential purposes. So where I have been in that term, combining that all together to single family residence, is how the single family residence is defined locally, whether it's a county or a city. Some cities, single family residence is a detached home up to 2 units. Other ones, it's even up to 3 units. Some, it's a single unit. And then this regulation states further that it has to actually be actively used, meaning that there is a tenant or a resident homeowner. It doesn't say that it has to be a homestead exempt single family resident. And I will say for those history buffs that that was in the mix way, way, way back when. And this didn't get included just for those residents that are that is their primary residence. It's any single family home, even rental properties qualify. Um, so it is actively, so a property that is vacant isn't actively a single family home. A vacant lot doesn't even have a single family home on it, although the lot may be designated for a single family home. So those are some key points that again go back to how different cities have looked at those properties and the land use itself and the condition of the property with or without a home gives them the right to then go back and have those tree removals be a code violation. And in my mind, for all the right reasons in those cases. The part that gets tricky is there are properties, single family homes, even in homeowner associations or not, where the property line in some cities, I'll just say Hollywood that I'm familiar with, the property line for most of the neighborhoods goes to the center line of the adjacent road, and the road, the sidewalk, the utility easements are all easements within the residential property. So the swale tree or the street tree is within their lot and could be removed within this statute. There are other communities, and I'll say Pembroke Pines, just again, another city we work in regularly, where most of the lots, the residence lot ends on their side outside of the sidewalk. So the tree in the swale is not necessarily their tree. An association, it'd be common area association, or it may be in the public right of way, even though cities require the resident to have the maintenance responsibility. So it's an arguable point in those particular cities, whether those street trees can be removed under this exemption versus every one of those needs to be permitted. And, you know, this exemption wasn't what do I say, put together for a statute because trees weren't being removed in tree removal permits. We're still developing at a very high pace in Florida. Plenty of
Yeah.
trees are getting removed through the proper process, with environmental mitigation considerations. this is a statute for, those properties that don't have the means or wherewithal. And again, my interpretation, but it can be used, for many properties. So let's go with another one. My
Yeah,
answers are
I would.
long, but hopefully informative.
Well, and I agree with what you said there, John. I think that that's a very important point that people need to be aware of. So, one of our anonymous attendees came in a bit late. Did you cover the BMP's use of shall or should, and if shall is considered to be required?
So again, with the BMP, it is as it stated. So the shoulds are shoulds and the shalls are shalls. And even some of the reviews and I have sat with some city attorneys and their reviews, especially for some code cases, wanting to insert the shall where it really works as a shall or it feels right to be a shall. We have to go back to the BMP states what it states. So again, like some of the terms, unacceptable risk as opposed to a high risk or an imminent hat risk or a probable. The terms to me weren't all taken from the when I say the BMP standards. For me, some of that was purposeful to allow for more interpretation than what it would have been, for many of us if they had just used the terms that are in the standard, if the standard is the reference. But it is what it is.
Yeah. So we got a couple questions in the chat. We should have probably just kept everything in the Q&A, but we got Lauren and Laura. We got
Yep.
two different Lauras, but I think this is actually a pretty great question. And she says, in my municipality, we frequently hear of tree services falsely telling homeowners that they don't need permits to remove any trees due to this statute. And then Laura concurred, and she says I then hit them with code enforcement steps. And in your area, are you seeing this sort of thing, John? Or
Yeah. So one if this happens and it's regular occurrence, I'll say that some of us call it the Saturday pickup truck on tour through the neighborhood, knocking on doors saying we're working down the street, we can remove that tree for $100. And there's this code that says that we can remove this tree, you don't even need a permit. So don't call anybody, just pay us cash today. Yeah.
yeah,
We in my neighborhood have turned away a couple tree services offering to remove some trees and palms, but they usually are running away after we're talking about certified arborists and code enforcement sections, and they think we're talking to them too long already. But the other part about that is that the sad thing is that the tree service in most municipalities, there is no action that comes against the tree service. The code violation goes to the property owner. So one of the things with cities that we consult with, and one of the things that I bring up regularly, so I'm bringing it up here today, is to get the code enforcement process to include, and this would be another opportunity to interact with your city or county attorney, include guidance for the property owner towards the responsibility of the contractor that they paid, check or cash, credit card or Zelle, but the payment made, the contractor's responsible to have followed those regulations. More so, and again, not legal advice, just my experience, more so than the property owner was responsible to know the regulations and make sure that the contractor followed them for them. So there are a lot more basically damage lawsuits, which not everybody wants to go through that, but you can hold that contractor responsible. And when the double mitigation and double permit fees for removing a tree without a permit that you're held responsible to do adds up to 5, 10, 15, or $180,000, depending on the number of trees, the size of your property. Um, Finding that in your wallet, in your pocketbook, in your bank account isn't always available. So I plead with code enforcement to give guidance to the property owners that you may look them in the eye and think they knew and they lied, but not always. And still, even at that point, it's still the contractor's fault for agreeing to do the work illegally. Just, and again, click my opinion, not an attorney.
I don't disagree with what you're saying. And my opinion is we should be going after those bad actors more
Yeah.
aggressively.
Yeah.
That's just my personal opinion.
Yeah, there's an opportunity in a few cities to at least have their equipment impounded and to go after them for their occupational license. You know, especially if they do get into the separate lawsuit, which is the damages lawsuit from the property owner to the contractor. There are more opportunities to punish them for their actions. You know, even beyond monetarily, if you know to include that with that attorney in the process.
And I think that's a good point that I think a lot of, our municipal arborists really kind of need to be start thinking about a little bit more. That's just my opinion. So I see here another anonymous attendee have had a code case where the house was not occupied due to renovation, and the special magistrate ruled that the tree would not have qualified to be removed under 163.045. So basically, they're concurring to exactly what you said a little earlier. If the house is not being occupied, it doesn't qualify.
And that's, you, I, and others may think of these terms as free to interpretations, but they're written specifically and they can be very strictly interpreted. And for me, it's easier, especially in code cases or other court cases, for every word to mean what it meant. You may not agree that a house under renovation that nobody was in, should have been exempted from meeting this regulation, but I will tell you the other thing that we recommend to every property owner that we write one of these reports for. Share this with your city, the city arborist, or we really tell them not just the city arborist, but share it with the code compliance office and have them just do a free or a preliminary review, or at least even if they tell you that they're not allowed to review it, and there are some cities where the city attorney has said you can't review reports that aren't part of a code case. We don't want to have anything to do with agreeing or disagreeing with trees removed under the statute. But there are other cities where at least they will say, thank you for providing it. I have no opinion of it. But if we get complaints, we will be able to say that there is a report that was written for that tree, and we may or may not be taking action in depending on our review of that report now that they have a complaint. Co-compliance in many cities gets activated based on complaints, not necessarily their own drive-bys. So we always tell the homeowner, and in that situation, if they had shared that report beforehand and had that discussion and got an agreement with code compliance that yeah, it's under renovation, but it's actually owned, and come back. So just another way to work outside the regulation, but to help support it and to help you as the arborist keep your customer client from getting into trouble, and not to waste code compliance's time with coming out and I too have been on a project that was gonna make the news because the tree being removed had multiple people in the neighborhood who didn't want it removed. And our report was a star witness behind the scenes. And it was a tree that met all of the reasons, that met all of the exemption, that didn't get
Mhm.
the code violation that the news was there to show. But other times the news is there to show, and it was a tree that shouldn't have been removed. So, anyways, go ahead.
Absolutely. John, so we got several different things going here with
Yeah,
between the chat and the Q&A. Hey, Mark, thanks for jumping on and participating here today. Mark Lang, he's another
yeah,
arborist down your neck of the woods, I believe.
yeah,
And he's right. A report is really no more than a snapshot in time, and that's important to remember. We
yeah,
cannot predict the future.
yeah.
And
Well,
then Bill,
this exemption regulation or statute, I keep doing it. It's a statute. I apologize, but has been around long enough that we have been brought out to do an inspection of a tree I'll just say make it easy. 5 years ago, we told them it doesn't meet the statute, but it's going to continue to have that crack open up. You may get deadwood in this area. So you may call back if you don't, permit removal this tree otherwise and come back 5 years later and it met clearly the exemption from a permit on that single family residence. So yeah, time will tell, but it is just a snapshot. It's the tree and the condition and the location and the property use on that date.
Absolutely. So William Fowler has a question. What are your views on destroying the tree as opposed to removal? In other words, removal of the primary stem by one half to bring the risk rating to or below moderate. This would require a removal permit in Miami-Dade County. It says we're
Yeah.
kind of threading
Yeah.
that needle.
Yeah. So in the standards is, following regulations and codes. So if your mitigation that would bring the risk below moderate as an alternate to removal would be removing I'd say the dead leader of the two leaders, which would cause you to have effectively destroyed the tree under the definitions in that regulation here being Miami-Dade County, then that's not an acceptable mitigation to bring risk below moderate as an alternate to removal. But I agree, it takes some education and some explanation because, the ability to cut enough so that the tree is only a 5 foot tall stump and not a risk to anybody could be considered, mitigation. But the rest of us consider that a destroyed tree every day of the week. So it
Yeah,
should have been
and
a
it's
removal.
just it's just an interesting, very interesting angle because
Oh,
it's like
it's
at what point
yeah.
you know part of the whole reason behind FS 163.045 was because of issues between the local municipalities and some individuals that kind of stirred up this whole pot and created this whole legislation. Yet we still run into this scenario where even this statute still runs afoul of the municipal code just based on is the tree considered destroyed, but we've mitigated it below moderate.
Right, right. Yeah, true.
So we got a few more questions in here, and I'd like to kind of turn this to James Weaver's question here.
Okay.
Um, to your knowledge, has anyone been subject to certification suspended or revoked due to fraudulent reports? And let me follow up on that, John, before you get into it,
Yeah.
because there's several people in the chat that kind of have talked about um, some things along those lines. And definitely, for our municipal people, I would recommend reaching out to Shannon Brewer. She's kind of putting together the whole municipal side of FUFC and kind of trying to get some groups together. But what are your thoughts on that? Is that something that we should be pursuing? I see Shannon
So yeah,
Kinney's
there
list.
there again is an opportunity to interact with your city county agency attorney. And that's I'm going to speak to those who are, employed doing the co-compliance side of this or enforcement side of this. There are some city county agencies where the accepted process is that the employees are not allowed to spend paid time to pursue the revocation of the certification. And there are others where that is supported and they are able to do that as a part of their job. It's sad to say that, but it is a time consuming process for, again, a lot of legal reasons to be able to go through the review board with ISA, but there have been actions taken and gone through the review board to get ISA certifications revoked. Um, so going through that process, to me could be, an opportunity for Florida ISA or FUFC to, do a webinar on what that process is and what the steps are to go through that and, what evidence proves the case or not. I think that's education that our memberships in both those organizations I would find useful.
I agree, John, and I'm glad that you bring that up because I think, Courtney, please make a note of that. We need to bring that to the education
Yeah.
committee because I do think that that's a very worthwhile presentation that people would like to hear about because I see a number of people chatting and we're all kind of skirting around
Yeah.
that issue of ethics and
Yeah.
bad actors and stuff like that. And
Yeah.
unfortunately, right now, um, just my 2 cents on that is that ISA has not been very transparent on that. I think that there's been a number of reports, to my knowledge, it really ramped up coming out of Florida because of FS 163.045. But
Yeah.
as far as actions that, you know, we don't know.
Yeah. Well, the point is that they are supposed to be private for, again, all the right privacy reasons. Florida
Right.
is a right to work law state, currently. So some of that comes into play as well. The other thing to get back to is getting a property owner to, be willing to bring a lawsuit for damages against the tree service that unethically wrote the report and got them into the code violation with all the costs thereof, can include review of and bringing into account the occupational license, whether in that locality it's only a county occupational license, or whether the city requires a separate occupational license to do work within the city. And the opportunity exists based on the outcome of lawsuits such as that to have that contractor's license revoked, which is then turns around to be an unlicensed tree service if they continue to operate and do this work. So that, the opportunity to be able to shut them down and impound their equipment and, have the police department do enforcement in conjunction with occupational licensing. So again, coordinating all of that isn't an everyday thing. I get that, but I will tell you that it is done in a few places. And again, there's another opportunity to try and move forward how to, support that ethical tree services, ethical arborists, that do this work are the ones that should be doing this work, which is why that we have these standards and education programs like today. But yet, you know, where we're all going to get in our cars and drive home and pass, hopefully not too many, but probably at least one location where we're going to say, that doesn't look right.
Absolutely. Absolutely. We're getting about to time here. Actually, we're a
Yep.
little over time,
Yep.
John, but I think um, I'm seeing some very interesting stuff here in the chat.
Yep.
Again, I think, in the Q&A, Laura had talked about, photo windows boarded up on a home,
Right.
um, all of that kind of stuff. And there was one question. Oh, Maria asked, has there been lobbying by ISA or others to mitigate the negative impacts of this legislation? So let's just kind of close this out. What is your feelings on what are the negative impacts
Well,
of this
yeah.
legislation?
So we're losing trees and tree canopy. So I will conclude with you know, the golden key that unlocks the opportunity to require replacement for trees that are removed under this exemption on single family properties. It's called a whole different set of regulations, zoning. So many cities have used their zoning requirements for how many trees per, square feet on a green space on a lot or the lot overall. And on the perimeter of the lot, especially street trees, requirements for street trees, every 20, 30 feet. And so they can, some of them have a waiting period of a week, 2 weeks, or a month before they bring that violation, but they will bring that violation that now you are missing required minimum uh, trees on the property and get the replacement for, trees that got removed. In some cities, dead trees that are part of the minimum requirements, obviously, were supposed to be replaced anyways, even if they are permit exempt as a hazard tree in that, where I live in Plantation as a for instance. But, going around and doing zoning compliance for how many trees are missing or not is, I'll just say,
That's
that's your next AI technology upgrade.
we'll just use aerial imagery for that. But
But
the point
yeah,
there is even though the statute has its purpose and its flaws, I think municipalities do have ways that they can kind of work around these things. They just need to be a little bit more creative.
we don't work around regulations, we work through them. We're not here to get around the regulations of the statutes. We're here to work through them better for everybody. So let me just end
Absolutely.
with this. This is a part one in 2026 related to the FS 163.045 statute. At UFI, we have a part two where I'm planning on focusing on and giving some more examples of those cities that have written the required sections into their codes and what that looks like in their codes. Like letters such as I have from Coral Gables and the presentation today, and also pulling from what we have here from the both the chat and the questions to be able to put some details towards some of this follow-up. So expect to be able to continue this discussion at UFI with me as well. And hopefully I'll have new information that makes it worth coming to UFI as opposed to today, the information that was worth being here for. And I thank everybody again for allowing me to be an educator with FUFC. Obviously, I enjoy it. And hopefully it's worth it for all of you. Thanks, John.
Thank you, John. We really appreciate you taking the time out of your day to meet with us here and put all this together. Definitely a lot of very thoughtful stuff. Good conversations. It definitely so much more to go on this subject of tree risk assessment. And I'm looking forward to the UFI segment and continuing forward with this because I think we've even talked about, a few other additional things as it relates to track.
Yep. Yep. We'll have more to come.
So stay tuned, everybody. Thank you for joining in. And hopefully we will see you here in a couple of weeks at our UFI, the Urban Forestry Institute. Courtney's put that link in. If you haven't registered, this is a great time to do that. And we will be seeing you very soon. Thank you all. Have a
Bye
great
now.
day.